Hi, I'm Lynne Haultain. I'm the Executive Director of the Victoria Law Foundation, and welcome to this year's In Conversation. And we are delighted to be in the old High Court, now the Supreme Court of Victoria, and honoured to be with Chief Justice Richard Niall. Thank you so much for having us.
Pleasure.
We meet on Wurundjeri land here in central Naarm, Melbourne, and I pay my deep respects to their elders and to all the generations of Wurundjeri people who have nurtured this land for over 50,000 years and continue to do so. We acknowledge the traditional owners and custodians of country across Australia, wherever you might be joining us from, and recognise their abiding connection to this land, the waters and community. At the VLF, we believe that acknowledging the past is an essential step in building a better and more equitable future. We recognise the impact of colonisation, its legacy of injustice, and the marginalisation of the Wurundjeri and other Aboriginal and Torres Strait Islander peoples. So, Chief Justice,
Lynne.
A very brief background before we start our conversation. You are the 13th Chief Justice of Victoria and you were appointed in February. 13 just struck me as a very low number given the history.
Yes, a few of my predecessors were there for quite an extended period of time. They didn't have a mandatory retirement age, of course, and so they were well into their 80s and perhaps even 90s. But so the period is shortening.
Is shortening because you now do have a mandatory retirement.
Of 70. Yes, it's a long and very proud tradition, but a relatively small number occupying a really very important position in the state, which I'm really honoured to take over.
So we've got you for a good time, not a long time?
Well, I'll be here for a few years.
You were also a judge's associate.
Yes.
Way back at the beginning of your career in the federal court. So you got an up-close and personal look at courts very
in this
early.
building. It's really nice to be back.
Coming home.
Yes, working in this building. It was a really great, very formative time for me.
Yes. Then you were a barrister for a number of years and you were appointed senior counsel in 2010.
Yes.
And then, as you mentioned, you became Solicitor General for Victoria, which is a really interesting role. It's a critical appointment, but it's inside the politics of the state to some extent. To some extent,
yes, definitely. So it was a big change for me. I'd been at the bar then for 20 years or 20 plus years and had a practice that took me doing a lot of public law, a lot of cases against government, a little bit for government, but most of my work was for applicants and plaintiffs, I think, in the public law space and also in industrial law. And I did a lot of work in the federal court and in the High Court. So I'd had a sort of large sort of federal practice. So being Solicitor General was bringing it all back to the Victorian focus. And it was a really enjoyable and stimulating job. It's got its challenges, having effectively a single client and
being
a client
the state.
Being the state, most closely through the Attorney General, but also through the Premier and other ministers. But having a single client, it was really rewarding. You do get an insight into how government operates, its strengths, its weaknesses, its complexity. Yeah, so it was a really good time.
And then you became a judge after you left the role of Solicitor General, which has become a bit of a well-trodden path, I have to say, looking at the recent Solicitors General.
Certainly in Victoria we've had a few join the Court of Appeal.
Yes. I want to take it right back to the beginning, though, because, like me, you came from a family of doctors.
I did.
But you chose the law. So was that against family expectation?
No, not expectation at all. My parents didn't really have. I'm one of 7 children, and my parents didn't have any set expectations of us, only that we would do things that we would find satisfying and rewarding. So there was certainly no pressure to go one way or the other. My father's father was also a doctor. One of my brothers is a doctor, so there was quite a lot of medicine in the family.
Yes.
But what I got from my parents wasn't so much being a doctor, but they both worked heavily in public hospitals. My father was a specialist at St Vincent's. My mother was a specialist at the Children's. And I saw both of their careers right through in public hospitals, seeing how rewarding public service was. And I think that's been a really important ethic for me that I've sort of tried to emulate or tried to keep as an important part of my life through my professional career. And I see a lot of similarities in hospitals and courts. We don't really get to choose who comes to us. We're there to... as a judge, to deal with the cases that's confronted, brought by the parties, either by the state or by individuals. Often people aren't there happily, and public hospitals are very same. There's often people under a lot of stress. They're not there because they want to be there, and they're very dependent on the professionalism and the quality of the doctor and of the nurses and of the allied professional health. And here, I think the parties are very dependent on the quality, independence and impartiality of the judge to decide their case, whether they're an applicant, respondent, plaintiff, defendant.
And we'll talk about that in a bit more detail in a minute, but I'm really interested in the medico-legal combination. My theory is that people who have a scientific orientation make for very strong lawyers.
I think that the logic of the law can be like the logic of science, that you're dealing with propositions, trying to establish them, built on a logical and rational sequence of steps. But I've tended to, when I was at the bar, and I think as a judge, tried to see the logical steps in the argument. Usually there's a logical coherence to the law, and usually there's a logical coherence to science. But I gave a paper a few weeks ago about science or mathematics and the law. And
did you?
Yeah, I did. And built, partly informed by where AI is going to take us in terms of probability analysis. And the thesis really was that although we use a lot of language like mathematical, balance of probabilities, probability is very much a mathematical concept as it is a legal concept. But there's a really profound difference because ultimately there's sort of issues of judgment, impression, and some may say that's the weakness in that is that you can be biased or you can be brought by influences that are sort of your own rather than an objective sort of assessment. That inherent weakness of human decision making, that we're all a product of our own environments. But at the same time, I think there's a real strength in that and bringing that human dimension to it. So I don't think the thesis was you can't really replace fact-finding and decision-making by mathematical formula, mathematical approaches. And I think that'll be a real problem for any attempt to substitute judicial decision-making with AI or robotic or mathematical formula based on probability, even though that's the sort of language that we speak. There's a fundamental difference in approach.
No, I completely agree.
But I do agree with you that, that logical theory, it's a really important logical approach. Valuable. Rational approach is really important to law.
People talk about loving the law. Do you?
I do. I love the practice of the law. I love what the law does for society, that sense of justice, that sense of that ultimately there is a place that you can go where there will be a decision in accordance with law by someone who's impartial. I think that's a really important part of our society, and it's a really important part of all societies, through, you had a very powerful acknowledgement of country, and of course Indigenous people have had very strong history of law, and dispute resolution and rules and very sophisticated rule-making process. And I think that's a really important part of any society, and it's a really important part of ours. We have some particular models, but it's definitely an important part of society. So I do love that aspect of it, and I like the practice of it. I've really enjoyed being at the bar. I like the contest.
Yep.
I like the battle. I thought the system worked best when you were opposed to a really good opponent.
Yes.
And you have a really engaged judge, and everyone sort of thrashes it out and tries to get to the right answer, with you pushing for your client, trying to win, your opponent pushing for theirs, and the judge having to really work through that contest.
It lifts everyone's game, doesn't it?
Absolutely. Absolutely. And it's more efficient, it's more fair, it's more just. It's why, we have legal representation and why self-represented litigants, which we're seeing increasingly prevalent in our courts across the country and probably across the world because of cost and disenfranchisement from the system, comes at a cost. It comes at a cost about the quality of the decision making, the pressures on the judge, the time. So yeah, but that's where that's where I thought the system operated at its best.
At its best, yes.
And I still, and I've loved being a judge. I've loved each part of my career.
Let's talk a little about the present part of your career. What does a Chief Justice do?
Well, there's a lot of different components to the job, and I'll try and explain some of them. But, I was on the Court of Appeal for 7 years. I was at a bar for probably 22, 23, 25 years, whatever it was. So you see Chief Justices, John Harbour Phillips, Marilyn Warren and Ferguson, and you see aspects of the job. But even as a judge of the appeal, I didn't really quite have a full appreciation of the depth of the breadth of the work, of the demands on a Chief Justice. So there are various pieces of the jigsaw. The most important, I think, or one of the most important, it's difficult to prioritise sometimes or rank, but I regard as one of the most important as being Chief Justice of this court, the Supreme Court. And that, I think, is judicial leadership's a difficult concept. Each judge is very independent. That's what we like. That's what we want. That's what we need. Independent, free-thinking judges who are operating in accordance with their understanding of law through an appellate process, so there's quite a good discipline there. So as Chief Justice, you're not telling judges how to decide cases. You're trying to create an environment of excellence, and that's sort of what I've set myself as a target. And my predecessor, Chief Justice Ferguson, had set a really positive tone within the court. Everyone, a real sense of unity of purpose. So it's a matter of fostering unity of purpose. It's a matter of fostering a culture of excellence, respectful environment, respectful of dealing with judges and dealing with staff, dealing with litigants, dealing with witnesses. But I'd have to say, in terms of that being a really important part of my job, when I came to the court as an appeal judge and as Chief Justice, I found the court incredibly collegiate, conscientious and respectful. So I haven't had to do that much in order to foster those really...
tone.
Yeah. But that's a really important part of the job. So, within my court, it's a really important part of the job. Outside of it, in Victoria, we've got some different components. We've got Court Services Victoria, which is an independent statutory body set up to provide administrative support to courts, and that's headed by a council called Courts Council, and that's made up of all of the heads of jurisdictions. So the Chief Judge, the Chief Magistrate, Head of VCAT, the President of the Children's Court and the Coroner, and some independent members, and I chair that. So chairing Courts Services Victoria is a huge part of the job. It's sort of ensuring that the infrastructure, the buildings are safe and functional and at the best they can be. The technology is there, that we're integrating across our courts as best we can, a sort of harmonious and integrated tech platform. Security is a big issue, both security of judges, security of staff, security of court users, both within and outside the building. That's a significant challenge. Human resources, the court system employs a lot of people.
So this is just it's
a big operation.
Administrative undertaking.
And the list goes on. There's the Judicial Commission, which is responsible for hearing complaints and determining complaints in relation to judicial officers and tribunal members, and also provides an educative role through guidelines. I chair the Judicial Commission, and the Judicial College is an independent statutory body designed to provide education for judges, and I chair that.
You are also the nominal chair of the Victoria Law Foundation.
I am, yes. So when I say important, extremely important.
But delegated in this instance. So.
And admissions board, one of the really important jobs as Chief Justice is to sit on admissions. That part of the work is really important.
It must be fun too.
Yeah, it's great fun. It's a time when you see a lot of, we do about 50 in a sitting. We have sit as a full court, 3 judges. I preside. And just seeing that enthusiasm and that joy on the behalf of the admittees is a really special part. And all of the judges, I tend to sit on all of them, but we rotate all of the judges, and all of them say what a really, really important and delightful part of the job it is to see that profession renewing itself and to see the enthusiasm as we get all a bit older and tired.
And it takes you back to the origins of your own career as well.
I think pretty much all of us were admitted in that courtroom. A few of my colleagues were admitted interstate originally, but overwhelmingly we were all admitted in that courtroom by our Chief Justice at the time.
So let's look at that in a little more detail, because literally 30 years ago there was one woman on the Supreme Court.
Yes.
Now there are 21 of 48, which is, a really significant increase. Some of us might say it's taken a while, but we are there, given, the number of people admitted. I think, certainly the number of graduates in law school is more female than male. So that's a really important, from a community's perspective, a really important reflection of the society in which we live and the people over which you will cast judgment.
Yeah.
So there's a job to do, I think, still to reflect the community in the ranks of our judicial officers.
I absolutely agree with that, and we've just talked about admission ceremonies, and one of the points I make, when I was admitted, which was 1991, no woman had yet been appointed as a judge of the Supreme Court. So it's within my professional life that there were no women on the court, and the court's been going for more than 150 years. And, it must have been extremely difficult for Justice Barmford, Rosemary Barmford, as the first appointed, coming into a court that had never had, the pressure on you. And I think there is the reality that, you have to exceed the expectations because the pressure's on you. And now, as we've moved in to get a much better balance and continually, and, gender doesn't come up on the radar now in appointment. And I think it's interesting that when one looks about the change, I think it's fundamentally changed the culture of the court.
How?
It's hard to sort of say in terms of any particular aspect that's different, but I think the culture of a more inclusive environment is profoundly for the good and profoundly different to one that's just men. And of course, it wasn't just men. It was white men from a very small part of the community. And overwhelmingly, they did an exceptionally good job. It was always been regarded as a very strong court, the Supreme Court of Victoria. But they were populated by a very small fraction of the community. And I think we've seen a fundamental cultural change for the best. The transition has taken time, nothing happening for a long period of time, and then even then it seemed slow. And it's still important to keep an eye on whether the court reflects the broader community. And I think one of the things is that there is a change in culture, there's a change in outlook, but there's absolutely no change in the legal decision making. There's no gender in the application of the law. There's no, women are more likely to favour this side or that side or this perspective or that side. I don't see that, and I don't think any of us see that at all. So it's got nothing to do with the application of the law, but it's got to do with all of the sort of cultural background which we all bring to the role, if you have a variety, you're bringing more different ideas, different strengths, different weaknesses, and I think it's much to the better. I mean, I think one of the things sitting on an appellate court where you're sitting with 3 judges, sitting as one of 3, and sitting as a court where there's 12 judges on the Court of Appeal, you need some creative tension, you need different perspectives, you need not everyone agreeing the same way. How you manage that has to be respectful and collegiate, and since I've been on the court, that's always what I've seen. But your point also about whether we're seeing other diversity, well, we're not yet. And I think part of that is something, it's really important for the reasons we've just discussed, to have that diversity. And I have a lot of sympathy for the argument that it's too slow, and opposition to the argument, it can't happen overnight. I mean, it's not overnight we're talking about. The court's been examined for 150 years. But in order to come to the Supreme Court, you need to have, 30 years of practice, 25 years of experience to come. So we've got to see that diversity
pipeline.
in the ranks. And I see it in the admission ceremonies every day. I see it across the 150 I sit in a day. You see that visual diversity, what you can observe. And I'm sure that the firms are now having a much more diverse cohort. And that breaks down stereotypes as well. As this particular cohort will act in this particular way or be strong in this
area of law.
This area of law or this interest, and I think it will develop. I really do. I think it takes work. I think it takes commitment, but I'm optimistic about it. But I think it's a really important outcome.
Agreed. I want to talk a wee bit about the role of the court, courts generally, in our democratic context. There is a tension, I suppose, in terms of the intent, the sort of democratic, high-minded intent, and the experience of the law. And I would imagine you would agree that knowing and understanding the law that you live under is a fairly basic tenet of a functional society, that we should know what it is that are our rights and that are our responsibilities. And given that you taught law, I wondered what you thought might be this sort of essential legal knowledge. What should every Victorian young person know about law in order to participate appropriately in our community?
Yeah, I mean, it's funny, we have this aphorism of ignorance is no excuse, which is a pretty terrible thing to say, really, as if the legal system just operates independently of the community that it serves, like it's external. In fact, the most important thing, I think, is understanding the system at least exists. And I think people have a basic understanding that there are independent courts. No one really wants to go to court.
No.
It's not a happy experience. But I think it's important that when we go through a stage, as I think we're going through now, of challenging to institutions of government, but even broader institutions, we've got to be sure that the people understand, what these institutions stand for, what they do, what their strengths are and what their weaknesses are. It's easy to expose their weaknesses. But we don't do a really good job of exposing their strengths and their importance, and that if you really, I really do understand the importance of challenging institutions to change them. But if it gets to the point where you're just going to destroy that institution with nothing in its place, you've got to know what you're losing as well. So I think in terms of civic education is a really important part of the picture. We don't live in a community where we'd be comfortable with, government announcements saying how good government is, or courts saying, how good
great
they are. Yeah, because people think, well, that's a sort of, people are sufficiently sceptical about that, and that's a healthy thing. So then you realise, well, we've got to convey that in a way that's meaningful to people, and that they can absorb in a way that's not cynical, that they don't view as a cynical exercise.
Yes.
You can go to a totalitarian regime and they'll be saying the government is fantastic, it's, doing everything for you, and everyone else is terrible. People don't, I think in our society, wouldn't warm to that sort of approach. As Chief Justice, I think I've got an important role in engaging with the community, in feeding the information or supplying the information or context for a lot of the work that we do, so that our communication with the community is not reactive, that we're only being involved when we're responding to a crisis.
Yes.
That we're providing a platform of understanding from which we can deal with these issues, which will be difficult from time to time. And I think putting a face to the court is important. There's risks because we don't want to personalise it in the sense that this particular judge is the sort of spokesperson for this court. We are very much a collegiate institution. We're not just a aggregation of individual people.
It reminds me of conversations which I'm sure you had too, which I certainly had as a student and afterwards, of people saying, I could not possibly be a lawyer because I couldn't defend somebody I knew to be guilty.
Yeah.
And you try and explain the appropriate context for that, the rights to representation, the fact that, everyone's innocent until proven otherwise, all those sort of precepts. But it's I think, an interesting confluence of the emotive response to circumstance and the very rational approach that we talked about earlier, and that those things come together in a way that people find a bit disconcerting.
Yeah. One of the things that what I think is one of the most important attributes of a lawyer and of a judge is objectivity. And I liken it to go back to a medical sort of illustration. You don't really want your surgeon to be so heavily emotionally invested in the survival of the operation that their judgment's impaired. You want them to be clinical, with empathy,
yes,
and acknowledging the difficulty that person who's having the operation is going under, but objective. And I think people, as a patient, responds to clarity and clear, bad news people can take. And I think as a lawyer, objectivity is a really important part. So it's not about defending a guilty person. It's really about ensuring that the system can work.
Yes.
And that's why, going back to something I said earlier, the system works best when you've got a very good
context,
practitioners on both sides and an engaged judge. And I think overwhelmingly that's what we get.
We have a situation, though, and this is borne out in our research at the VLF, where people are either, they're not accessing legal information or legal help because they don't know they can, often. Sometimes, in fact, in a significant proportion of cases, people don't understand that there's law in their problem.
Yeah.
They have a life problem. It's got a legal dimension, but they don't see it through that lens, which is understandable. So they either don't know they can, or they feel they can't afford it. So this goes to the classic access to justice question, which is eternal and universal. What changes have you seen in that regard? Do you think, from our point of view at least, there is greater awareness, I think?
I think at a number of levels within the court system, I think we've seen, and this is particularly in the Magistrates' Court and the Children's Court, but also in the county and in the Supreme, we've seen a greater awareness that a lot of the problems that bring people to court, be it in the Children's Court, child protection, crime, in the Magistrates' Court the same, a lot of these problems are multifactorial and often sadly intergenerational. And trying to get the supports, and I think legal aid and the Federation of Community Legal Centres do a fantastic job of trying to get a bit more of a holistic support for some of their clients, recognising that resources are always a difficult issue for these things, and a lot of these problems are very, very
knotty,
difficult, knotty and tractable. But I think there is an awareness that if we're to be successful, we do have to look at the broader social issues that are involved in some of the poverty and intergenerational trauma that results in crime or results in family disruption. And I think, in the work that's being done in the family violence area, again in the particularly Magistrates' Children's, but also the County Court, in ensuring that there's a lot of support. And, the way we build our buildings are different now. We've just opened, the Attorney General last week opened the Wyndham Law Courts, a very large and significant public building in Wyndham in the western suburb of Melbourne. And there are different access points for people who are there in relation to family violence matters. So there are safe waiting rooms. There's a whole lot, and there's some really quite therapeutically inspired areas for the children to go to, recognising that people might be at court for a long period of time. So, yes, there's an awareness there within the system of that level. Outside of it, I think there's still a lot of work to go in terms of ensuring that people have access to lawyers and a recognition of the importance of lawyers. The demands on legal aid are so great that there's very little in civil, for example. So that's a massive unmet need, partially filled by the Federation of Community Legal Centres. There's 46 community legal centres in Victoria. There's thousands of volunteers and there's employed staff doing amazing work in a whole area, a range of areas that provide legal support for those who can't afford it or don't qualify for legal aid. So there's work being done, but it's I think that's still a significant challenge.
Yes. We talked a wee bit about self-representation and the challenge that presents. To go to the tech question, we will see significant shift both in the practice of law and in the experience of it for people. I wonder if AI could help with access to justice.
I think the idea, if it is there, that we can immunise the legal system from AI is, to my mind, not very realistic. The scale of the change and the rapidity of the change, the pace, are such that it's inevitable that AI will be a feature of the legal landscape. I've met with a number of the firms and discussed what products they're using and how they're using it, and they're very conscious of the risks associated with the use of AI, including where the data is being stored. Is it being stored in Australia? Is it going overseas? Is client confidential information being made available outside, and how is it being controlled? They're very conscious of those things, and so they're cautious in relation to the adoption of technology. But they see internationally and in Australia that it'll be a significant productivity gain in the preparation and hearing of matters in court. In the courts, the Coroner's Court is doing a really interesting pilot in relation to using an AI product to assist in the preparation of coroner's reports. They're not prepared by AI, but they're assisted by AI in matters which are very significant in the sense that a loved one or a family member has died. There's been a necessary investigation by the coroner, and the coroner has to produce a report. If it can simulate a lot of material quite quickly, which is not necessarily controversial, it's not contentious, but can assimilate that and provide summaries checked by staff within and by the coroner, then that might be a really good way of efficiently producing or assisting the process. So there's AI currently piloted in the Coroner's Court, which is looking really quite positive in relation to that particular area of work. In relation to other areas, we're looking at conducting pilots in my court in relation to the use of AI to see whether it can assist. Again, not being the judge, not writing the decision, not replacing the analysis, but in terms of some of the assistance. Now, that's a very, very cautious steps, and we haven't quite worked out how that's going to implement it, but it's something that in order for us to understand how the profession are using it, I think we've got to have a little bit of an experience ourselves. There are risks, of course. There's a lot of talk about AI can produce hallucinations, can make up cases because it's just looking at all of the vast material and creating what's probable.
It's looking at language.
Looking at language and what's statistically probable in a very, very sophisticated way, and producing outcomes which read like a very reasoned outcome as we would understand it. That there are limitations in treating that as a reasoning process. But I think those risks, there are also opportunities. And I think there are real opportunities for access to justice. We are seeing some self-represented litigants using it, and sometimes it's slowing things down rather than helping.
Because?
Well, because they just seem to be giving us more and more material, and more versions, and more, and the quality of the material is, on its face, looks sensible, but it's completely unprincipled in the sense that it's not based on any known approach to principle. So, unpicking it can sometimes be difficult. So it hasn't yet got productivity gains, but I think I'm cautiously optimistic that I think there will be productivity gains, access to justice gains.
So the conversations, many and varied around AI, but there is anxiety on the part of young lawyers about what it will mean for their experience of the profession. And I remember hearing, and this is some time ago now, and I'm sure things have moved on, those of us who remember spending way too many hours poring through folder after folder after folder of documents in a boardroom.
Yes.
It's just part of your sort of apprenticeship, if you like, in the law. That is very likely to disappear altogether as a standard experience for young lawyers. But I suppose the question I would put to you then is, if you were starting out in the law now, given the perspective you have, what would you be spending your time on? Where would you see the opportunity and the excitement, if you like, for the future of the law?
I think when you're at law school, you're learning, and this was true when we were at law school, and I'm sure it's true now, you're learning some substantive law, but you're also learning analytical skills, analytical method. And when you start as a young solicitor, or when I was article clerk or graduate now, often there's a lot of pretty menial tasks of document collation, summaries and all of that, and not a huge amount of sophisticated legal analysis. You might do the odd memo at something. I think the importance is appreciating what skills that you're learning along the way, and it's important for the firms, small, medium or large, to work out what skills they need for the future, of which they need to develop. And I think the two things that will probably come of it, one of my friends is a partner at a firm, and he'd gone over to see Microsoft with some other firms, and he came back and his observation was time costing is dead. And so they've built up a model based on billable unit and time costing. When AI is going to replace a lot of that, it's very quick, obviously. So that just makes you think, what are you actually providing to the client?
Yes. What is the inherent skill?
What's the value? What's the judgment that and what are you therefore instilling in your graduates? And it's the analytical skills, it's the judgment. Ultimately, I think there'll still be judgment calls. And I absolutely understand the high risk that if we take away these menial or, junior tasks, will the firms hire graduates, and will they learn, and what are we going to do with the new cohort? To come back to your question about where I would focus my time, I mean, I think in everything you want to do, you want to find things that you find rewarding and stimulating. I think one of the challenges for lawyers is you don't really know what's rewarding and stimulating until you sort of see it. And it's really often one of the valuable things when you're a junior lawyer is doing a job that you don't like.
Yes.
Because you realise that's really not what I wanted.
Yes. And that can be a surprise sometimes.
Yeah. They were saying, I've always wanted to be a probate lawyer, and then they go and do probate and they realise they don't like it. Or they didn't want to be a probate lawyer and they do probate and they really enjoy it. Or they do whatever it is, family law or criminal law or commercial law. And one of the things, so I think it's finding things that you find rewarding, but also taking the opportunities. So that'd be my advice to the young practitioners, is think about what skills that you're developing for yourself and take the opportunities, including what you don't think you may like. And if you don't like it, think about what other ways you can do it.
That you need to find out.
Yeah, and I think when I look at people who have sort of succeeded in the profession, if you like, a lot of them have just taken the opportunities.
Is that not true in life? I think generally.
Yeah, it's not a peculiarity to law.
Yes, you find yourself in unexpected places.
Yeah, and taking that opportunity. And also I think, and the younger people now are better than it was when I was graduate. They probably see a longer time frame. I think, when I was, I do in one sense. At least in this sense, when I was an article clerk in the first year, second year, everyone said, well, you should be a senior associate in 3 years, and then you'll be a partner in 5 years. And there was much less movement across the firms. People saw a much cleaner trajectory. Now I think people are more comfortable saying, well, I'm doing this for 5 years and I'm going to do something completely different. We might have a whole generation of people who just keep chopping and changing, but at least there's an opportunity to sort of test a few things and see which ones you find rewarding, and it's usually those things that you do best in.
Yes, which might present some challenges for the judiciary, given the depth of experience you need in order to...
broad experience is good for us as well. I mean, it's an interesting feature of the profession is that when you start at the bar, for example, where I was, you tend broad, and then you tend to narrow as you become a specialist. And, I was sort of specialist, for want of a better word, in sort of public law and industrial law, but other areas. And then you become a silk and you become sort of even more specialist. And then when you join a court like the Supreme Court, it's a generalist court, and particularly the Court of Appeal sitting across, and you realise those transferable skills across all of the areas of the law, the analytical skills that I spoke about, they're very transferable. They hold good, absolutely hold good. And I think they actually hold you in better when you understand some of the interrelationships between the legal theories that underpin different areas of law.
I want to talk a bit about how you manage, given the breadth of your portfolio, the intellectual demand of what you do. I know you're a marathoner. I know that you are a member of a running group. Mm-hmm. But in the end, marathon running is a solo pursuit, as is being a judge. And it struck me that there are two dimensions to that. One is the sort of, loneliness of the long-distance runner. Yes. The time that both takes and offers mm-hmm. in terms of your own mental space, but also the need to connect and to do something completely out of kilter, if you like, or out of the zone of the law and the court.
Yeah,
I've just thrown all of that at you. Respond as you will.
I think this is probably a pretty common experience. I was busy at the bar, and then we had a family. We've got 3 children. And so, that occupied a lot of time. It was either working or family, and there's, and friends, of course, are important. And then probably in my 40s, I sort of thought, well, I ended up catching up with some friends, and we'd go to the gym twice a week and we'd run, and we're still doing that. So that's now, 25 years we've been doing it, and we'd meet every Saturday morning at about 6:30, and no matter what state we were in.
That's brave.
And during the week, and then run, and we did some runs, and then we built up to marathons very, very slowly, but we did a lot of talking. But a couple of things were important. One is they weren't lawyers, so I got that sort of just a different perspective. So when you talk about, a lot of my friends when I was at the bar, barristers, and still friends, judges, and we talk shop, and I'm sure doctors talk shop, and I'm talk plumbers, and everyone's, farmers, whatever it may be, journalists or whatever it may be. So having that side of it where you're not talking about cases, and no one ever really asked me, what case you're doing. Very occasionally one would come up, but, it just wasn't a feature of the conversation. And running and gym were really good because it was sort of something that you could do. It would be a set period of time, and then you go on and do your rest of your life.
Yes.
And it didn't involve too much eating and drinking. In fact, it was so when you look at too. It was definitely. And you look at when you look at, for me, socially, catching up would involve going out, eating, and it's much better to see these people regularly, but doing something that we all enjoyed. But we were running so slowly that there was plenty of talking. So it wasn't. It was. I never did any.
It's not so solo.
No,
then.
I never did. I never do any running by myself, really.
But being a judge can be a fairly isolated experience. I know you were on the Court of Appeal, and you always sat as a member of the bench of 3. But when I have had the opportunity to speak to judges, there's a lot of time spent in court listening and then retreating to consider and write. And it's, you have associates and there is collegiality, of course, but everybody's involved in their own particular cases at the time. So it strikes me as an interesting mindset or sort of character that takes well to this discipline.
I think it's one of the virtues and one of the risks of the job is that it is, you do need to get, I think you do need a sense of self. You do need to be able to go back to your chambers and feel pretty comfortable with what you're doing. But because it's a risk, one of the things that I need to do as Chief Justice is foster that collegiality so that there is that support. And having a collegiate court, judges sitting across different divisions talking to each other, there is a shared sense of purpose and a shared sense of experience. So it's actually, although ultimately you're the one responsible for putting pen to paper, finger to keyboard, whatever it might be, there's still a deep sense of us all working together for some common sense of purpose, and that's very satisfying and rewarding for people. I think I went straight to the Court of Appeal, and I've sat quite a lot in the trial division, and I find going to the Court of Appeal, the advantage was that I'd have two other people.
Yes.
The problem was shared in a sense.
But also the challenge was in two other people?
Yes, but yes, there's that, and also, every judgment I wrote got reviewed by the Court of Appeal, whereas for the trial division, most of their judgments didn't. So there's pressures as well going straight to the Court of Appeal. Look, I think it's definitely something that is a feature of the job but it's a feature of being a barrister as well. You have that responsibility of standing up and presenting the argument. Actually, when you're on your feet, there's no one else who really but basically
you're on your own. Mm-hmm.
So a lot of us who are at the bar have sort of got that, used to dealing with that sort of sense of individual responsibility for the product. But I think the individual burden can be really difficult, and I think people talk about how hard it is to be a barrister, and it's stressful and it's difficult and you feel responsible. Judging is very burdensome, but at a different level, and so you look at judges and it is tiring. It's like physically tiring and it's mentally draining, and sometimes that sense of isolation can really compound the difficulties for judges. So that's why we spend in our court a lot of time doing things to make sure that there's support for judges and support for their staff as well. And not only is it solitary, but a lot of the material is very confronting.
Yes.
And we see it not just in the Supreme Court, in the County Court, the Children's Court and the Magistrates Court. Extremely confronting material, and we're pretty conscious of the risks of trauma, both for judicial officers and for their staff, and we're constantly working about ways to protect against that. But, a judge has to confront the material in some way.
We are going to wrap this up. I've taken too much of your time already, I'm sure. But finally, judges are seen as emblems of wisdom. I think, that's a very strong trope in our culture and in our society broadly. You listen, you think deeply, and you decide. Who are the touchstones in your life and world that you see as wise, that you draw on?
Well, my parents were both wise. My father was a specialist physician, and he was very considered in his approach to clinical judgment, and had a very, very good reputation at St Vincent's as being a very considered practitioner. In fact, the funny story was we had a holiday house, and in the middle of the night one of the registrars rang him, and Dad woke up in the middle of the night and took the call, and the registrar gave an explanation of this very sick patient. Dad was a kidney specialist, so it would have been someone pretty sick in the middle of the night. And then there was a pause, and the registrar said to someone, "The old bugger's fallen asleep." And my father said, "No, the old bugger's thinking."
Still awake. He's thinking.
He's thinking, trying to, and that. So he was pretty considered. So that I've always seen that as a pretty valuable approach. And my mother was also very thoughtful in her approach to her clinical work as well. So I think they were sort of two exemplars of that sort of wisdom approach. And there are many, judges. Don Ryan was a very, very thoughtful man, and could synthesise very complex things in a very concise way. So, I think like being a barrister, being a judge, there's elements of the trade where you've got to work out some of the basic skills of being a judge and then building on it.
Yes.
And part of it is just synthesising complex arguments and expressing it in a simplistic, not simplistic, but manageable way.
Yes. There's a
elegant way.
Yes.
Don Ryan was a very elegant writer and a very elegant thinker. So, you have those people who you want to emulate.
There's a wonderful phrase about finding the simplicity through the complexity, so on the other side of complexity. And certainly in my experience, the people I've found very impressive have been able to express things, as you say, elegantly and generally with concision, but through having considered a great deal of complexity.
Yeah.
And they come out the other end with a very
Like a lot of
clean
things, when you see a
understanding.
great silk in action, it's the simplicity. It all looks so perfect, you know. And when you try and do it, you realise there's a lot of moving parts.
It's harder than it
You're
looks.
it is harder than it looks, and that's the beauty of a great sports person, the beauty of a silk, the beauty, so those sort of just trying to get that sort of simplistic approach or simplifying things is sort of, and looking at those people who have sort of modelled that behaviour,
Yes.
and there's a number of them.
Thank you always for having us. It's
Pleasure.
been such a
Thank you for coming.
delight, and
It's nice to have you at the court.
we look forward very much to seeing you again.
Thanks very much, Lynne.